Firstly, thank you all for coming. Very much appreciate you giving up your time to be here. Here's the book on the right-hand side. I know you've all bought your copy and read it, and if you haven't, you're going to, because of the discount code over there. So before we get started, I do want to give a little bit of context to what an intermediary is and what an intermediary role does, because some of you here will be very well aware of what the intermediary role involves. We have some of our RIs, registered intermediaries, from the scheme in Northern Ireland. Some of you will have no idea whatsoever. So I'm going to give you a really crash course in about 1 minute on what an intermediary actually does, to provide some context to the book itself and this research area. So intermediaries were introduced in 1999 through the Youth Justice and Criminal Evidence Act as part of a package of special measures. Things like screens in court, evidence by a live link, judges being able to remove wigs and gowns from the barristers to create a better environment for children to give evidence. But one of the special measures that was part of that cohort of measures was the intermediary. The intermediary is the only special measure that is a person. It's normally a speech and language therapist or a social worker in Northern Ireland, slightly different than England and Wales. But the intermediary will conduct a communication assessment of a vulnerable witness or defendant. They will then produce a report providing practical recommendations to the lawyers and judge in a court or at the police station, police officers, about how best to communicate with that vulnerable person. About half of appointments in Northern Ireland are for children, but it can also be for older individuals and vulnerable adults as well. So in Northern Ireland, the pilot scheme for the intermediary scheme started in 2013. And one of the key facets of our intermediary scheme here that's different to England and Wales, that will be a feature of the next half an hour, 40 minutes or so, is that in Northern Ireland, intermediaries assist vulnerable accused persons, suspects at the police station, and defendants at court, as well as witnesses at the court. In England and Wales, the statutory entitlement to that role only exists for witnesses. Let me just be clear about that, because people find that hard to believe. In England and Wales, there is no statutory availability for this role, this support role. Okay, so that's been called a two-tier system, where you've got witnesses having a registered model and defendants not. In Northern Ireland, since 2013, we have had a unitary system. So intermediaries assist both witnesses and defendants. That's the background. So the format of the book launch is going to be as follows. We're going to start with some remarks from Dr. Penny Cooper, who's on the call, who sadly wanted to be here but couldn't make it. I'll then speak for about 15 minutes, max 20, about the book and why I wrote it, some of the themes. And then we're going to have Jenny Humphreys, who's an intermediary in Northern Ireland and a speech and language therapist, come and have a bit of a Q&A in a nice, relaxed, conversational way. So save your tough questions for them. Before I do hand over to Penny, I just want to say a few words, which I hope won't preempt too much of what Penny's going to say. To say that Penny's work has been instrumental in the development of the intermediary role would be a big, big understatement. Penny is regarded as the world expert on intermediaries and practice and policy of intermediaries. Penny co-founded the Advocates Gateway in 2012 and trained the first witness intermediaries to support communication with vulnerable witnesses in England and Wales, and in Northern Ireland as well, and in Australia. Penny also co-wrote the Registered Intermediary Procedural Guidance Manual in England and Wales, the Australian Capital Territory, and recently undertook a comprehensive review of Tasmania's Witness Intermediary Scheme pilot in 2024. Penny also devised, I could go on, Penny also devised the pilot scheme for intermediaries in New South Wales and co-trained the intermediaries there as well with Michelle Madison. Penny examined my thesis in 2022 from the London School of Economics, and ever since she's been an extremely supportive mentor and, I'm very glad to say, a good friend as well. I was delighted that she agreed to write the foreword for the book and also to say a few words to open this evening. So I'm going to hand over to Penny. Thanks. Penny.
Great. All right. I feel slightly discombobulated now because all those words of praise, John. I'm sitting here, I was on mute saying, stop it, but thank you all the same. And so good evening to everyone in the audience and everyone online. I'm very sorry I can't be with you in person, but the travel arrangements proved to be just too complicated. It's really an honour to be asked to speak this evening, and it was an honour to be invited to write the foreword to John's book. I'm also going to go back in time just a little bit, but not repeat what John said. It's almost 23 years ago to the day that the Office for Criminal Justice Reform awarded my team at London City University the contract to train the first intermediaries for vulnerable victims and witnesses in England and Wales. The pilot scheme began in 2004, and 2 decades ago, we, and when I say we, I mean myself and my law school colleague David Wurtzel, we were starting from scratch in terms of educating intermediaries, the police, and the courts about the role and how it should operate. As you can imagine, we really had our work cut out addressing a wide-ranging lack of awareness and understanding about why intermediaries were even needed at all. Significantly, as you've already heard, defendants were excluded from the statutory scheme. As you can imagine, that also didn't help to endear the scheme to defence solicitors and defence barristers. A few years after the intermediary scheme was established in England and Wales, David Wurtzel wrote in the Bar's Circuiteer magazine how intermediaries were puzzled by the exclusion of defendants from the statutory scheme. In that same magazine, His Honour Judge Michael Lawson described how judges in England and Wales had found ways to, I quote, legitimately circumvent, close quotes, that omission. However, all sorts of problems still remained, including how to find and fund suitable intermediaries for defendants. The absence of a formal scheme for defendants remained a very real issue until recently in England and Wales. There's still no statutory scheme, but there is now at least a formal scheme. But from 2012, Northern Ireland began forging ahead, designing their intermediary scheme to quite rightly include defendants, as well as victims and witnesses. This enhanced approach came about because judges at Largonside were aghast when David and I explained on our first ever visit that defendants were not included in the statutory scheme. Excluding defendants was something up with which the Northern Ireland judges would not put. The legislation was amended, and so it was that Northern Ireland's DOJ led the way internationally by introducing a scheme which from the start has included defendants. In the very early days in England and Wales, when David Wurtzel and I were developing guidance, it evolved thanks in large part to anecdotal evidence that came from intermediaries and some quite basic research tools and methods. I think back, for example, to a hastily drawn up paper questionnaire handed out at the end of an intermediary workshop. Thankfully, intermediary research has moved on. It's become more widespread and more sophisticated. And for example, I was invited to externally examine the PhD thesis of one John Taggart. And here we are this evening. His research and dissemination continues. The book that is being launched this evening shares with us the results of John's wide-ranging interviews and detailed analysis. An exploration that is so much more than simply what intermediaries do. It's qualitative, empirical research on how they operate, the scope of the role in the criminal justice system, and the challenges intermediaries face. This sort of research moves practice forward, as will his current research, focusing on the right to effective participation at the police investigation stage. John has recently completed a series of interviews in police custody with custody sergeants, forensic nurse practitioners, appropriate adults, and registered intermediaries. The research aims to better understand how communication needs are identified and accommodated at the early stages of the criminal justice system. The particular focus is on how intermediaries are integrated into police processes. Whilst tidying my bookshelves recently, something which retirement allows me to do, I came across the very first procedural guidance manual for intermediaries. It's a lever arch, no less, practically a relic of a bygone era. And what does that manual say about how intermediaries integrate with the police process? Well, the guidance says amazingly very little indeed. Much has been written about intermediaries in the court process, but historically too little attention has been paid to the intermediary role with the police. An anomaly when one considers that most of the work that intermediaries take on is conducted with police, in police stations and in specialist police interview suites. John is addressing that research deficit with seasoned research skills and an unparalleled international expertise on the role of the intermediary in the criminal justice system. I take this opportunity to say a big, warm-hearted thank you to intermediaries, and thank you to all those who work collaboratively with intermediaries. And well done, and of course, thank you to John. I feel that the future of intermediary research and the resultant positive impact it will have on the criminal justice system is in safe hands. Thank you, John.
Thank you very much for that, Penny. And before I continue, I just want to completely echo what you just said, and not the last thing, that was about me, the penultimate thing about intermediaries, and this being a celebration of intermediaries. I totally agree with that, because we have a few intermediaries here tonight, and the work they do is often underappreciated. It's often appreciated in good cases when it goes right, but it's very often underappreciated. So if part of this is to celebrate the role, then I totally second that. So in the next 15, 20 max minutes or so, I want to cover three broad areas. Firstly, why I wrote the book, then explore a few key themes from the book, which you've all read anyway, so you know, and then a few comments on the future directions of the role and where it might go from here. Before that, and I really think this is an important point that I thought about this morning after I typed up my notes last night. This book is about intermediaries. It's about a specific role, but it absolutely has broader impact beyond a specific special measure role. When we think about what access to justice means, when we think about what participation means, when we think about what a criminal trial is, when we think about any of these key concepts about justice, whilst we're talking about a specific role, hopefully some of this actually has ramifications and consequences beyond the specific thing we're talking about tonight. Why did I write the book? So it was 2013, and I was doing my criminal defence pupillage in the Bar Library in Belfast. And I was also working as a teaching assistant here at Queen's. And I thought that was the best of both worlds, really. I was able to practice law and see how it was practiced at the coalface, and then look a bit more in depth at teaching the law, but also think a bit more abstractly and conceptually about the law. And I realised then that actually I didn't think purely practice would be enough for me. I would always be interested in academia and what that might look like. A man in the front row here, Dr. Clay O'Neill, I was living with his brother at the time, and I asked Clay about what he was doing with his career, and Clay was pursuing academia, and I said I'd like to write something. And Clay encouraged me to write a book review of Simister and Sullivan's Criminal Law for the Criminal Law Review, and I hadn't a clue what I was talking about, really. And they published it. So I thought, OK, I can probably write a bit, even though I was way out of my depth. But very shortly after that, the intermediary pilot scheme started in Northern Ireland. And Veronica Holland, who Oliver and Jenny are probably know much better than me, I dropped them an email and said, look, I've just started my pupillage. I'm interested in this new role, the intermediary. I had never heard of an intermediary. I knew about special measures from evidence, but I hadn't a clue about intermediaries. And they said, this is great. We've got someone in practice interested in looking at this. Things happened and it fell by the wayside, and I transferred to the Bar of England and Wales. I was practicing in London, criminal defence. Started doing a bit of teaching there as well, and didn't think much more of it initially. Then increasingly in court, particularly in the magistrates' court, I started seeing the word intermediary being used. Now, in a magistrates' court in England and Wales, you have a district judge or a legally qualified judge with 2 lay magistrates. Nobody had a clue what was going on. Yes, there was going to be an application for intermediary being made, but nobody really knew what that meant. The lay magistrates really were asking questions about, is this role an interpreter? Do they replace us? It was just, I tapped into this real lack of understanding. Now, I didn't understand much either, but I thought there's something here. So with a bit more practice, and I was teaching a bit more, I thought I'm going to make an application for a PhD, really on a whim, to the London School of Economics, no less, thinking, well, I may as well put it in. And I got a call from Linda Mulcahy, who had a chat with me, and only at the end did I realise I was being offered a PhD at LSE. I thought, OK, I can't say no to that. So the PhD and what came of it from the results led to the book. The book itself has got a little bit more of an international context and comparison than the PhD originally, but that hopefully gives it a bit more salience internationally for people in Australia, New Zealand and other countries. So the book itself, that's part one, 2 parts to go. The book is based on a series of interviews, semi-structured interviews with intermediaries themselves in Northern Ireland and England and Wales, judges in Northern Ireland, which the judiciary here were very helpful in terms of organising, not so much in England and Wales, I have to be honest. We have a different sort of legal culture here, and it lends itself to that, thankfully. And a few police officers in England and Wales, but COVID sort of paused that. The research is socio-legal. I didn't really know what that meant when I started my PhD. I was told this was a socio-legal PhD, of course, and the funding was tied to that. I didn't really know what that meant. I quickly realised this is socio-legal. We've got the law in the books. What does the legislation say about this role? But what do the people on the ground actually do? How do they see the role? How do they negotiate the role in practice? What about resistance from lawyers and judges? That's what I was interested in, and that's what the book, the PhD, fundamentally looks at. So there's three key themes from the book that I want to delve into a little bit more. And I'd be really interested to follow this up in Q&A. The neutrality of the role, what it means to be neutral when being an intermediary. Professional status, something that surprised me in the interviews. What does it mean to be a professional in the criminal process? I think we haven't got to the answer on that one yet, but it's definitely a theme. And thirdly, participation, and that definitely has consequences beyond this role. What does it mean to participate in a criminal process? And how do intermediaries impact that? So the first one, neutrality. This surprised me from the data. I didn't expect to be asking intermediaries in an interview about how objective or neutral they feel. But it was really obvious early on, and it was something that I pursued in later interviews, even with judges. How important is it to this role to be neutral and impartial and objective? And what does that mean for its practice? I've got 3 intermediaries in the room. I would hazard a guess they all agree that it's very important. Because you're not an interpreter, you're not a friend, you're not a supporter as an intermediary. On paper, you're there as an objective, neutral communication conduit, and you're not allowed to take sides. That's easy to say on paper, isn't it? What I found, and this is absolutely no criticism of intermediaries, it was less of an issue in Northern Ireland, I have to be honest, but the emotional work that is involved in dealing with very vulnerable people, the most vulnerable people in society, vulnerable witnesses, vulnerable defendants, is emotional work. And especially those intermediaries who come from a caregiving background in speech and language therapy, social work, other professions, it seemed to be difficult at times for them to suddenly recalibrate and complete this role in a totally objective, neutral way. Northern Ireland had less of an issue with that. I'll speak about that more towards the end. Professional status, I didn't think this would be a big issue at all, but it was one of the key themes in the book. And this, again, should have relevance for other types of lawyers out there beyond criminal lawyers. What does it mean to be a professional or a criminal justice professional? What I soon found out talking to lawyers and judges, and intermediaries too, of course, that judges and lawyers zealously guard the confines of their court and their system. You know, there's a term used by Jacob and Eisenstein in the 1970s, the court work group. So you've got judges and lawyers who seem to be at loggerheads in this adversarial system, but they're actually working in a pretty efficient justice way that promotes case efficiency and management. Intermediaries coming into that from an outside perspective, lawyers seeing that as a threat. Well, I ask questions in this way. I always have. I've done it for 40 years. And one of the quotes I'm sure the intermediaries will resonate with this. I have children of my own. I know how to speak to children. You know, that was quite a common thing I heard. So the resistance that lawyers had to this external role coming in and telling them how to do their job, essentially, or suggesting changes to their practice. Now, there's literature on probation officers and interpreters, them feeling and experiencing resistance. Intermediaries experience the same from my own work on this. Is it a professional role, and what does that mean going forward? We'll maybe pick up on that in the Q&A. And the third theme is about participation, and this is something that we're hearing more and more when we talk about access to justice and participation. Witnesses have a right to participate in criminal proceedings, so do defendants. But defendants have fair trial rights that witnesses don't have. They have a right to effective participation. Intermediaries, make no mistake about it, in some of the most vulnerable cases with vulnerable defendants, intermediaries are absolutely essential to that person getting their voice across and effectively participating in their case. If you're an intermediary, you're probably thinking that's an obvious point to make. But actually, when you look at the literature on what it means to participate, we all participate in our lives in various ways, but in the court, what it means to participate as an accused person actually means something very specific. Do you understand the evidence against you? Do you understand what it means to plead guilty? Do you understand the risk of testifying? Do you understand your sentence, etc., etc.? For some of the most vulnerable people out there who are defendants, some of those are real challenges. And the best intermediary practice enables those people to be able to participate. And that's a fundamental principle or finding of the book as well. Reflecting on those and looking at the future directions of the role, I could speak for an hour on this, but I won't. I'll focus on 2 points. The second one's about where the role goes internationally and how it might develop in other countries. But this point I'm going to make was a chat I had with Jenny about this, and probably other intermediaries too. Do intermediaries represent a scaling up of existing criminal justice professionals? That there's been a deficit of good communication skills for years, and intermediaries come in to train lawyers how to communicate better. And then ultimately, when those skills are acquired, ultimately this role maybe slowly goes away or diminishes. That's a very tough question to answer, and I know there's division among different stakeholder groups about that. I think there's something to be said for lawyers getting better at their job, doing the basics. Can you ask a question in a simple way with one simple point? If an intermediary is needed to come in to help you do that, then fine. But one of the reasons I think this role's here to stay, again, this won't surprise some of you, is that the level of vulnerability in the justice system and the extent of it is really only being scratched. The surface is only really being scratched. This is about criminal courts. This has not been extended in the same way or to the same volume in family courts. Do you think there's a need in family courts for this type of assistance with some of the most vulnerable? Of course there is. Employment tribunals? Of course there is. I've been doing a bit of work with the charity IFJ in Catherine O'Neill in England and Wales. And they're looking at how a similar role, or the intermediary role, might be introduced in professional disciplinary hearings or regulatory hearings. What about parole hearings? What if you're a prisoner and you're going in front of a parole hearing, a very, very important decision? Does participation matter at that point? I would say it does. If you've had an intermediary during your trial, should you have one at your parole hearing? I would suggest you do. So I don't think the role is going to diminish in that respect. But if we get lawyers to upscale a little bit about asking questions in a simple way, then maybe that's one element of legal practice that can change. Very, very, very last point I'll make, and it's just about where the role goes internationally. The model that we had in England and Wales that Northern Ireland adopted in 2013 is now being replicated in other places. Australia, every territory or state except Northern Territory has some sort of intermediary model. In some states, it's for witnesses and defendants, in Canberra and ACT, increasingly in Western Australia and Tasmania. New Zealand are making great strides in this. But the vast, vast majority of countries don't have anything akin to an intermediary. If the book goes some way, and maybe I'm being optimistic, if the book goes some way to exhibiting the good work the intermediaries do and how it can be implemented in other places beyond Northern Ireland and beyond England and Wales, then I hope it has that impact. And then people can buy the book and then, sure, everything's great. I'll finish on that. Just one final thing to say. And I do think it's important to say this. We're from a relatively small jurisdiction and we very rarely get things right ahead of other countries, or we're very rarely in the driving seat. Penny said this, and it's absolutely right. And if she says it, I'm going to tag on to it. Northern Ireland is doing this better than anywhere else. Australia and various states and territories in Australia are looking to hear about how we do things. We are, in the words of Declan Morgan, the Lord Chief Justice in 2013, really important point, equality of arms demands that this type of assistance is available for defendants and for witnesses. Equality of arms, it's a simple concept, but our judiciary took that very seriously when this rule started. It's not the same everywhere around the world, so if Northern Ireland, little old Northern Ireland, can lead the way in that, then I think we should be proud of that. I'll leave it at that. Thank you. Jenny, you're being summoned. We're going to have a bit of a Q&A now. I think Jenny might have a question or two. If you don't, that's fine. But I think you're going to come up here, Jenny. We're going to take some questions from the audience. But thanks. And I think these mics work. They do.